Welcome to the PVW Law video library discussion regarding pet trusts. What is a pet trust? A pet trust is a legal arrangement that provides for the care and maintenance of pets upon the pet owner's death or disability. The trust is typically created by the pet owner and provides assurance that any pets left behind will be cared for in the manner desired. Who should have a pet trust? Because pets are legally regarded as tangible personal property, all pet owners should consider incorporating a pet trust as part of their estate planning process. However, pet trusts may be particularly useful for pet owners who live alone, are of advanced age, suffer from chronic illness, or have multiple pets that the owner would like to keep together. Pet owners should also consider creating a power of attorney that gives an agent authority to care for his or her pets. Doing so will assure short-term care of a pet in an emergency. The three most common types of trusts used for pets are the honorary trust, the statutory trust, and the traditional trust. An honorary trust is essentially a request to the trustee to care for the pet. With this trust, the trustee is not legally obligated to abide by the request, therefore, honorary trusts are generally not recommended. Most states have passed laws authorizing the creation of statutory pet trusts. A statutory trust is a bare-bones trust created for a pet by reference in a will. A statutory pet trust is the least formal trust. The approach is tax ineffective, as the IRS has ruled that all pet trust income will be taxed to the trust even if distributed for the care of the pet. This type of trust may not provide the type of care desired by the pet owner. The traditional trust is the recommended tool for the care of a pet upon death. A traditional trust is a written formal agreement whereby a pet owner creates a trust and places ownership rights to his or her pet under the control of another person, the trustee. The trustee may or may not be the caretaker of the pet. The traditional trust provides the pet owner more control over their pet's care. Trust provisions can include the date the trust begins, usually upon the pet owner's death or disability. The beneficiary of the trust, usually a human caretaker. A mandate that distributions be made to care for your pet. Specific care instructions. Compensation for the trustee. A traditional trust provides for distributions to the caretaker. These distributions are taxable to the caretaker and deductible to the trust. The trust should consider a caretaker's income tax liability. What does the pet owner need to decide? First, the pet owner will need to select a trustee for the trust. The trustee will be responsible for managing and distributing the funds held in the trust. A successor trustee should also be considered, especially if the original trustee is an individual. Next, the pet owner will need to select a caregiver. The caregiver is the person who will provide care and maintenance for the pet when the pet owner is unable to do so. A successor caregiver should also be specified in the trust so that there is continuation of care in the event that the original caregiver is unable to do so. Finally, the pet owner will need to determine the amount of assets to leave in the pet trust. The amount placed in the trust should be the amount necessary to provide the desired standard of care for the pet. The pet owner should also decide a beneficiary who will receive any funds remaining after the pet's death. What directions and information should be included in the pet trust? A pet trust should clearly identify all pets. However, the trust language should be broad enough to include pets that are acquired after trust creation. The pet owner should clearly describe the desired standard of living and care of the pet. That is, the trust should include an explanation of nutritional needs, veterinary care, type of home, and grooming details. The pet owner should provide directions for the pet's burial or cremation. What are the income tax consequences of a pet trust? The income earned from the assets in a pet trust is taxable for income tax purposes. In the case of a traditional trust, if the trust is a grantor trust and funded during the pet owner's life, any income will be taxable to the pet owner. If the trust is irrevocable, which is typically the case after the pet owner's death, The trust will be taxable on its income unless it is distributed. When income is distributed from an irrevocable trust, the distribution recipient will be taxable on the income. The income of a statutory pet trust is always taxable to the trust regardless of distributions. As a result, the statutory trust can be tax ineffective. The income of an honorary trust is also always taxable to the trust regardless of distributions and can be tax ineffective. Pet owners should consider both the short-term and the long-term care of pets as part of their estate plan. The benefits and disadvantages of each strategy for pet care should be considered. A decision should be made based on what will best meet the goals of the pet owner regarding the care of the pet. If you would like to consult with one of our estate planning attorneys about creating a pet trust, please complete the estate plan intake form on the Client Tools section of our website at pvwlaw.com or email us from the Contact Us tab.